All right.
Saturday, May 23rd. The Supreme Court just ended it. A massive 6-3 ruling, dropped via a midnight filing. Presidential immunity?
Gone.
127 pages of raw legal opinion, dissent, and raw constitutional analysis. I spent the last few hours reading through every single page. Every line of the majority opinion, every angry word in the dissent, the actual, literal language used by the justices. This changes everything. That is not hyperbole. That is a direct reading of the situation. According to official court documents released at exactly 11:47 p.m. Friday night, the Supreme Court voted decisively to strip immunity protections from sitting and former presidents in cases involving alleged criminal conduct. That is not a close call. That is not a marginal decision. That is a legal landslide. Let me show you exactly what the ruling says, what the Trump legal team's immediate response tells us about their internal panic, and why this specific decision matters to you, your money, and the future of the country. First, let us establish some quick context. Donald Trump, former president, current defendant, facing multiple federal cases involving alleged attempts to overturn election results. The fundamental issue before the highest court was simple. Can a sitting or former president claim absolute immunity from criminal prosecution based on their official acts while in office? The Supreme Court just answered that question with a resounding no. Decisively. Let us look at the fast version of the timeline to understand how we got to this midnight crisis. Last summer, Trump's legal team filed emergency motions claiming absolute presidential immunity. 3 months back, lower courts rejected those immunity arguments entirely. Then, on Wednesday, May 20th, Trump's attorneys requested the Supreme Court to fast-track the case to get a final decision. By Thursday, May 21st, internal discussions among the justices were heating up behind closed doors. And then, on Friday night, May 22nd, the ruling came down. 6-3. That is the setup. Now, let us get into the actual opinion. This was not the court being cautious. This was not a panel of judges hiding behind safe, ambiguous legal jargon. It was the court being incredibly direct, clinical, and sharp. Chief Justice John Roberts did not hedge his words. Neither did any of the other 5 justices who formed the majority. The central logic running through the entire 127 pages is simple. Presidents are not kings. Nobody in the American system gets blanket immunity from criminal law. But here is what makes this extraordinary. Emergency midnight rulings do not happen often. In fact, they are incredibly rare. They only happen when the court collectively believes the stakes are so incredibly high that they warrant bypassing normal, slow procedural rules. On Friday night, the majority believed exactly that. What does that mean for the cases moving forward? It means the justices felt the core question was urgent, highly constitutional, and fundamentally dangerous to leave unanswered. Okay, let us look at the direct evidence. The first document was filed Friday, May 22nd, at 11:47 p.m. I pulled pages 23 to 27 from the electronic docket. It says, and I am quoting the majority opinion directly here, the president enjoys no immunity from the criminal process. The president is not above the law. No person in this nation is above the law. Look at that phrasing. That is not ambiguous. That is not open to multiple creative legal interpretations. That is categorical. What it means in plain English is this. Presidents can be prosecuted. Full stop. But here is what really got me when I dug deeper into the text. On page 34, in a completely different section of the filing, the majority systematically addressed every single immunity argument that Trump's defense team had put forward over the last several months. The official acts defense? Rejected. The separation of powers concern? Addressed and neutralized. Historical precedent? Explicitly overruled. They went through each argument methodically, coldly, without any political theatrics. I went through this section 3 times just to make sure I did not miss a nuance. The pattern is clear. The court was not angry when they wrote this. Worse, they were entirely clinical. Let's talk about the immediate fallout from the ruling. Trump's federal cases are set to resume immediately. Federal prosecutors can now proceed with their schedules without hitting the immunity wall every time they file a motion. The state cases in Georgia, which had been experiencing procedural slowdowns, now have the green light to move forward. The New York cases remain completely unaffected. Within 72 hours of this drop, expect a wave of multiple legal motions from Trump's remaining defense team as they try to patch up a sinking ship. Now, let us look at what nobody in the mainstream media is covering yet. Let us turn to page 47. This is the dissent written by the 3 justices who voted against the decision. They argued, and I quote directly from their filed text, "This decision undermines executive authority and exposes future presidents to politically motivated prosecutions." That is their core case. That is their warning to the country. Here it is, plain as day. But here is what is truly remarkable about how this document is structured. The majority opinion did not just ignore that warning. They addressed that exact concern directly on the very next pages. They wrote that while they acknowledge the separation of powers, and while they recognize that executive independence genuinely matters for the stability of the state, immunity from criminal law is simply not necessary to preserve essential presidential functions. Let me translate that translation for you. Presidents can do their jobs perfectly fine without having a shield against criminal behavior. Why does that matter? Because the court essentially established a new baseline. You can protect legitimate presidential power without protecting individual presidential criminality. Let's look at the specific, hard details from the ruling to understand the sheer volume of what just dropped. We are talking about 127 pages total. 6 justices voted for stripping the immunity protections. 3 justices were dissenting. The breakdown of the writing itself tells a massive story. 34 pages were dedicated entirely to the majority's legal reasoning. 28 pages were consumed by the heavy, warning dissent. And 19 pages were filled with concurring opinions. The concurrent section is where things get genuinely fascinating. Justice Jackson wrote separately because she wanted to go even further than the main majority opinion. She argued that the court should have rejected the immunity arguments even more strongly, shutting the door tightly against any future variants of this defense. Think about the translation of that dynamic. Some justices within the majority actually thought the collective ruling was being too careful. That tells you everything you need to know about the internal temperature of the building. When the more liberal-leaning justices think a historic, sweeping ruling is being overly cautious, you know the baseline has shifted significantly. The documents also revealed internal court discussions that somehow leaked to select journalists just hours before the public ruling went live on the portal. One internal source, reportedly a high-level clerk within the building, stated that Friday night was, quote, "the most serious moment in this court's term." That is not casual language used by someone passing time. Read that phrase again. That changes how we view this. The timing itself is what truly matters here. A midnight ruling on a Friday night, processed through an emergency docket, is a massive signal. In the last 40 years of Supreme Court history, emergency midnight rulings on this specific scale have happened maybe 3 times total. This was treated by the institution itself as an absolute, unprecedented urgency. Constitutional scholars, including several who were public Trump supporters before Friday night, are now coming out and saying that this is historically massive. A quote from a prominent constitutional law professor at Georgetown University, published early Saturday morning, sums it up perfectly. This ruling will be studied in law schools for decades. It permanently settles a question that has hung over the American presidency since the days of Watergate. That is not hyperbole from an outside commentator. That is their own internal assessment of the significance of May 22nd. The majority also made sure to address the long-term practical concerns of the country. They noted that immunizing presidents from the reach of criminal law would create a deeply perverse incentive structure for anyone holding the office in the future. It would make presidents less accountable to the public, not more powerful in their execution of duties. Authority without accountability is precisely what the framers of the Constitution sought to prevent when they drew up the system. It is right there on page 51. So, the baseline reality is established. The framers did not intend for immunity, presidents do not require it to lead, and the law applies to everyone equally. All of it is documented in the official opinion. Now, let us pivot to what everybody is missing in the chaos of the news cycle. If this granular document breakdown is useful to you, hit that subscribe button right now. There is a lot more coming on this story as the separate filings drop. This specific ruling has deep, systemic implications that you have not heard explained on the standard evening news. I am going to keep breaking down exactly what happens next and what the actual legal timeline looks like over the next few weeks. Subscribe to stay ahead of it. The stories are developing incredibly fast. Okay, but look, we have to be completely fair here. The other side of this debate has a legitimate point to make. In fact, they have a few points that deserve serious analysis. Trump's legal team, along with several conservative constitutional scholars who support the concept of executive immunity, are arguing that this ruling is fundamentally dangerous for the executive branch. And honestly, when you look at the mechanics, some of their arguments do hold up under scrutiny. Let us look at their primary argument. First, they argue that presidents need psychological and operational breathing room. If every single controversial, high-stakes decision made in the Oval Office can be prosecuted by political opponents the second an administration changes, the office of the presidency will become completely paralyzed. Second, they argue that this ruling opens a massive, dangerous door to the weaponization of the justice system. The next president will face constant, non-stop legal attacks from the opposite party's prosecutors, turning the presidency into a game of survival rather than leadership. Third, they point out that international precedent matters. Most major Western democracies protect their chief executives from daily legal entanglements because they recognize that the top office requires absolute independence to handle international crises. Former Attorney General William Barr put it very clearly in a statement early Saturday morning, warning that this decision will haunt every single future presidency and that no future president will feel secure making tough, gray area calls under pressure. Now, I do not agree with all of that logic, but that is certainly not nothing. What the defense side has are legitimate, deeply rooted separation of powers concerns. They are raising real questions about future prosecutorial abuse and pointing to historical examples of political weaponization across the globe. Even legal scholars who heavily opposed Trump's specific immunity claims in the lower courts admitted that the Supreme Court had a very narrow, careful path they could have walked here. This decision, however, is not that narrow path. It is significantly broader, and that has people worried. That is a direct warning from a Yale constitutional law professor who previously testified against absolute immunity. Look, I am not here to tell you who is politically right or wrong. My job is to show you exactly what the legal documents reveal. The majority opinion demonstrates clearly that presidential immunity has no actual basis in the literal text of the Constitution. Historical precedent simply does not support the idea of an immune executive. The framers explicitly rejected royal immunity concepts when they broke away from the crown. Other modern democracies function entirely fine without giving their leaders a total shield against the criminal code. On the flip side, the Trump legal position argues that total protection is the only way to ensure executive independence from a rogue judiciary. There is evidence of that concern throughout modern political history. But what the majority is effectively saying in response is this: you are conflating basic executive power with criminal immunity. They are two entirely separate things. Both frameworks can possess internal logic. Presidents do need some protection from administrative distraction, but criminal immunity is not the tool for that job. That is exactly what makes this situation so incredibly complicated. What I can tell you for a fact is that the documents show the court voted decisively. This was not a fractured 5-4 squeaker of a decision. It was a solid 6-3 ruling backed by dense, historic reasoning. When 6 federal justices, including individuals who were directly appointed by Trump himself during his administration, still vote to strip these immunity claims away, that tells you everything about the overwhelming legal weight behind the final decision. But here is where the tension gets incredibly tight. William Barr is arguably right about one specific thing. Future presidents will now face a completely different level of legal exposure than any of their predecessors ever did. That is an undeniable fact. But from the court's institutional position, that is not a constitutional flaw. That is simply how the rule of law functions when applied equally. Nobody gets a pass. The dissent, led by Justice Thomas, Justice Alito, and Justice Gorsuch, keeps hammering the point that the presidency becomes functionally impossible under these new conditions. The majority counterargument is simple: no, it just becomes normal, like every other high-stakes job in the world. Both sides have a framework, but the court picked its lane, 6-3. What I can confirm directly from the text of the documents is that this debate is legally settled for the foreseeable future. The era of claiming total immunity is over. The next big question, and it is a question that almost nobody in the media has started asking yet, is this: what happens right now to the pending cases? That is where the reality of this ruling hits the ground. This entire situation did not just appear out of nowhere. Let's look at the quick backstory to understand the momentum. Last summer, Trump's legal team first brought this specific immunity argument to a lower federal court. The sitting district court judge rejected it outright, calling the defense's argument completely baseless under current law. 3 months ago, Trump's team appealed that rejection to the circuit court. They got the exact same result, different legal reasoning from the panel, but the exact same destructive outcome for the defense. Then, the Supreme Court requested full briefs from both sides. That is when the real, high-stakes institutional fight started. Someone close to the matter even noted on the record from Trump's lead attorney on Friday morning, just hours before the midnight drop, quote, "This court has an historic opportunity to protect the institution of the presidency itself. We deeply hope they will take it." Obviously, they did not take it. What did the defense do next? They doubled down at every single turn. Look at the pattern over the last year. First filing was an absolute immunity claim. Second filing was a functional immunity claim. Third filing was an emergency stay request to halt everything. And every single time, they lost ground until Friday night. The defense team genuinely thought the High Court might grant a temporary stay, a strategic pause on the ruling while further complex appeals could be mapped out. They were completely wrong. The final opinion did not just reject the immunity claim. It rejected the foundational idea that this question was even a close call. Chief Justice Roberts wrote very clearly in the main text, "This question is not novel. The law on this matter is not ambiguous." Let me give you the direct translation of that statement. We are not inventing new law tonight. We are simply confirming the old law that has always been there. That matters immensely because it proves the court felt total institutional confidence in this decision. This was not a tentative, experimental, or deeply split compromise. It was a statement of constitutional certainty. The court also took the time to address exactly why the concept of presidential immunity seemed plausible to so many people for so long. They noted that past presidents certainly received broad, respectful deference in complex legal and administrative matters from the courts. But deference is not the same thing as total immunity. There is a massive, historic difference between those two concepts. You can respect the dignity of the office without placing the individual officeholder entirely above the criminal law. That is the sharp distinction the court is making, and legally speaking, they made it airtight. Do you see where this entire trajectory is going? It is moving fast. Following the legal trail is the only way to not get lost in the political noise. Hit that like button right now if you want more of these document-focused breakdowns. That like button is the only way we... Let us return to the exact timeline of Friday night, May 22nd, at 11:47 p.m. Eastern Time. The moment the Supreme Court released the 127-page opinion, the room went silent across the legal community. The moment that specific quote, "The president is not a king," went public on the wire, the reaction was instantaneous. Trump's legal team was forced to issue an emergency statement within exactly 12 minutes of the upload. Defense attorneys immediately announced desperate plans to appeal whatever elements they could and seek immediate administrative stays. On the other side, federal prosecutors confirmed within the hour that their cases would officially resume on Monday morning. Just like that. That fast. Now, let us look at what everyone completely missed while they were staring at the flashing breaking news banners. While the public was entirely focused on the headline that immunity had been stripped, something far more dangerous was happening inside the text. The majority opinion did not just state that immunity does not exist in the present case. It said something much stronger. It stated that the very question of presidential immunity was never a legitimate legal dispute to begin with. Turn to page 15 of the official opinion. It says, and I quote, "We note that this question would not have reached this court had counsel not advanced an unprecedented interpretation. The law on this matter has been settled for centuries." Let that sink in. Translation: this should never have been a multi-month controversy. The defense team invented a controversy out of thin air, and the court just called them out for it publicly. Then, look at Justice Jackson's concurrence, stretching from page 103 onward. She went even further into the mechanics. She argued passionately that the court should have rejected the immunity claims with prejudice, meaning permanently, with no option for any future legal team to ever bring a variant of this argument back to the building. While that aggressive stance did not make it into the final majority baseline, its presence in the official filing shows the intense internal pressure building within the court's chambers. You can literally feel the friction in the language. Here is what happened next on Saturday morning that the mainstream media completely overlooked. Emergency motions were filed by Trump's team requesting, and I have the exact electronic filing language right here, an expedited stay pending further systemic appeal in light of this unprecedented ruling. That was filed early Saturday morning. The court's official status response? Denied within less than 2 hours. No long explanation. No weeks of deliberation. Just a swift, institutional denial. That is not normal court procedure for a case of this magnitude. When the highest court in the land denies an emergency stay request from a former president without even providing a paragraph of explanation, the court's own language from page 45 to page 52 systematically dismantled every single counterargument in advance. That proves they fully anticipated the massive political criticism and the public pressure they would face. They addressed every single objection preemptively so that the document could stand on its own 2 feet. Why does that level of preparation matter? Because it proves the court did not just stumble into a historic decision under political duress. They thought through every single angle, every consequence, and every historical pivot point. Justice Elena Kagan's separate concurrence, which was signed by 2 other justices, added a line that is already going viral across legal circles. She wrote, "The office of the presidency is elevated, but it is not insulated." That specific phrase, elevated but not insulated, is now the official legal standard moving forward. Universities are already updating their constitutional law courses for the upcoming semester. Major law review journals are rushing analysis pieces to press. This is moving through the entire legal ecosystem not as a debatable political topic, but as settled, permanent law. That kind of baseline shift happens incredibly fast in the legal world. When the highest court speaks with that level of finality, the entire profession has no choice but to listen and align. Let us look at a useful breakdown of why you should actually care about this beyond the political drama. Let us talk real talk about how this affects actual people on the ground. First, let us talk about money. If you donate even $5 to political campaigns or PACs, you need to pay close attention to this. Trump's various legal defense teams and associated leadership PACs have raised an estimated $83 million from small-dollar donors over the last 18 months alone. That money, your money if you're a donor, is going directly to paying armies of high-priced lawyers who are now facing a completely clear path to trial. Expect the legal fundraising appeals to intensify dramatically over the next 48 hours as the reality of multiple simultaneous trials sinks in. Next, let us look at the concept of precedent. This sets an immediate, unyielding precedent for the future. The next time any American president faces a serious criminal investigation, this exact ruling applies to them automatically on day 1. For a quick example, if President Biden or any future administration were to face federal charges down the line, they cannot claim executive immunity as a delay tactic anymore. The rules of the game have changed permanently for everyone who will ever occupy the Oval Office. Who is directly affected by this right now? There are an estimated 127 individuals directly involved across the various federal cases who are now dealing with the shockwaves of this ruling. Federal prosecutors are already moving forward. That was clearly not an authorized comment from the campaign leadership. It tells you everything you need to know about the intense internal disagreement breaking out behind the scenes. The legal strategy is splitting into two camps. Some advisors are saying to exhaust every minor procedural appeal to extend the timeline and delay the trials at all costs, while other, more business-minded advisors are saying to accept the High Court's ruling, move to the settlement negotiation table, and protect the remaining core business interests. It is not cooling down behind closed doors. It is heating up exponentially. The external fighting posture is colliding violently with the internal reality of calculating the next tactical moves. The cost-benefit analysis for his team has to be brutal right now. More trials mean millions more in non-stop legal bills, which means even more exposure of sensitive internal documents during the discovery phases. On the flip side, settling or pleading means admitting massive personal liability, which brings immense political pain. There are simply no good options left on the table. That is exactly where the defense stands on Saturday morning. What remains entirely unclear as we move into the weekend. First, will Trump's team attempt to seek a rare administrative stay from a different judicial combination while they draft secondary filings? The High Court gave a very clear no on Friday night, but they might still try to knock on that door again, out of sheer necessity. Second, will the state-level cases in Georgia move significantly faster now that the federal immunity cloud has been cleared away? Georgia prosecutors signaled a definitive yes on Saturday morning, but complex multi-defendant trials always take time to organize logistically. Third, how does this historic structural shift reshape the volatile dynamics of the 2024 election cycle? We are entering completely uncharted territory. Let us look at what is coming up next on the official calendar, so you know exactly what dates to watch. Federal prosecutors have mandatory scheduling meetings on Monday morning to announce their immediate next steps for the main trial dockets. Trump's remaining legal team is currently working through the weekend, preparing formal appeal briefs that are legally due by May 29th. Presiding judges are expected to issue brand new, finalized trial date orders by June 2nd. Mark May 29th on your calendar right now. That is the critical date when the next round of legal briefs are due on the portal. That is the exact moment we will learn Trump's true, finalized strategy for handling the post-immunity landscape.
We should know a lot more by then.
In the meantime, the state-level cases in Georgia are advancing steadily, and the New York matters are already moving through their next procedural phases. For the first time in the history of the country, multiple powerful jurisdictions are proceeding simultaneously against a former executive. Full legal exposure. Absolutely no immunity shield left to hide behind. Make sure you are subscribed to this channel. I am going to cover every single one of these heavy legal developments the exact second they drop on the electronic docket. The story is moving faster than the mainstream media can keep up with. Hit that subscribe button, turn your notifications on, and I will break down the upcoming May 29th appeal briefs line by line the moment they are filed on the record. Subscribe to make sure you catch it. Let us do a final recap of exactly where we stand right now on Saturday morning. The Supreme Court's immunity ruling is completely final. It is a historic decision from the highest court in the land, meaning no further standard appeal is possible on the core question. The federal criminal cases are set to resume with full, unrestricted prosecution authority on Monday morning. Trump's legal team is currently scrambling to develop a secondary strategy before the upcoming May 29th briefing deadline. Looking at the upcoming schedule, May 29th is the deadline for appeal briefs to hit the federal court portal. On June 2nd, the presiding judges will issue new, binding trial date orders. On June 15th, the Georgia jurisdiction will hold its major trial scheduling hearing. And June 20th stands as the potential, projected trial start date for the primary federal case. What is not public yet are the quiet, high-level internal discussions regarding potential plea deals, adjustments, or settlements. Those critical conversations always happen behind heavily closed doors, away from the media cameras. But the clock is running loud and clear for everyone involved. Multiple trials, multiple distinct jurisdictions, and simultaneous complex proceedings. The last time a former American president faced a legal gauntlet of this scale? It has never happened. Not once. So, the entire legal system is essentially figuring out the logistics of this crisis in real time, day by day. That is the reality of where we are. Donald Trump is legally exposed in ways that no former chief executive has ever been before in the history of the Republic. The surface-level read of the situation is simple. The presidency does not grant a lifetime shield against the criminal code, and standard legal accountability applies to everyone equally. But the broader, deeper constitutional moment is what truly matters for the future of the nation. The Supreme Court did not just rule narrowly or safely on a minor technicality. They ruled decisively, 6-3, utilizing incredibly strong, historic language that sends a permanent message far beyond Donald Trump as an individual. It is a permanent message directed at every single future president who will ever take the oath of office. The law applies to you equally, without exception. As we move into next week, I will be watching 3 critical things very closely. 1. Whether the upcoming defense filings manage to extend the trial timelines or if the judges accelerate the process toward July. 2. Whether the separate state jurisdictions cite this specific high court ruling to aggressively push their own cases forward onto the summer calendar. And 3. Whether anyone in Congress attempts to respond with complex, late-stage legislation, which is highly unlikely given the political gridlock, but always technically possible. This historic story is nowhere near over. It is simply developing into its most volatile phase yet. The highest court has spoken definitively. The text of the Constitution has been interpreted for the modern era. But the massive, real-world legal consequences? Those are going to unfold slowly over the next several months, right before our eyes. Subscribe to this channel for the full, unfiltered picture based entirely on official documents, not just sensationalized media headlines. When the raw files drop on the portal, when the trials proceed in open court, and when the appeals are filed, I will be right here to walk you through exactly what the text means. No political drama, just the documents. Thanks for watching. Toxin out.